Estate litigation comprises a whole world of potential litigation against an executor, administrator, or trustee under a last will and testament. Most people are aware that probate is the process whereby a person offers a last will and testament for probate, which is to say, offers the last will and testament to the court, and the court then will pass upon the validity of the last will and testament. Frequently, when a last will and testament disinherits somebody who feels they're deserving of receiving an inheritance, this person will show up in court and inform the court that they wish to contest the validity of the last will and testament. The way a probate contest proceeds is someone will offer the last will and testament to the court and ask that the court admit it to probate, thereby passing on its validity. After having filed this petition with the court will hold a hearing date at which they invite any person who would receive if there was no last will and testament to come to the court and inform the court if they wish to contest the will. If this person informs the court they wish to contest the will, the court will schedule what is known as a 1404 examination, which is a deposition and a quasi-hearing of the person who is potentially offering the will for probate, as well as the attorney who drafted the last will and testament and the witnesses to the last will and testament, whereby the person who wishes to contest the will have an opportunity to ask them questions to ensure the will was properly executed. This 1404 examination is the absolute pivotal moment in any probate contest. Only in examining the attorney prepared the will and the witnesses to the will can someone rest assured that the will was validly executed. Different grounds for contest include undue influence, whereby an objectant states that they believe that the person who is now deceased was under the influence of the person who is to receive either lion's share or perhaps all of the estate under the last will and testament. Another objection to a will is that the person lacked capacity. Commonly, a person with Alzheimer's, if they signed a will while they were suffering from Alzheimer's, may or may not have legal capacity. Another ground for contesting a will is if it is believed that the will is either a forgery or is a fraudulent document. The second major area of litigation is litigating who should be the administrator of an estate. When someone dies without a will, the law provides that certain people have priority to serve as administrator. Typically, if there's a surviving spouse, this person has priority. If there is no surviving spouse, the people who have priority tend to be the deceased person's children. However, that being said, even with a surviving spouse, or if there's no surviving spouse and children, there can be a dispute as to the appropriateness of appointing that person as administrator. The law provides that certain people cannot serve as administrator of an estate. For example, if they've committed a felony, or if they have otherwise shown themselves unfit by having stolen assets, filed for bankruptcy, or if they have substance abuse problems. The third area of estate litigation, which we'll discuss today, is the litigation concerning the accounting of an executor or administrator. It's not uncommon that an appointed executor or administrator may have perhaps unknowingly made improper distributions or improper payment of debts, or in the more extreme cases, has in fact totally neglected their responsibility as executor administrator and essentially stolen estate assets for their benefit. When this happens, a client would ask the court to formally issue an order requiring that the executor administrator account for all his or her actions in serving as executor administrator. Once the court issues this order, the executor administrator is required to account. The accounting must be backed up by bank statements and receipts, including canceled checks from the estate bank account showing what was actually paid. In addition to this, the executive administrator will be examined under oath almost immediately upon filing his or her account. So the person who has any objection or any concerns regarding the accounting can question the executive administrator as far as their accounting is concerned and as far as the production of bank statements and canceled checks is concerned. Unfortunately, people do get greedy and people do make mistakes, but when they do make these mistakes, they are held accountable, and only in bringing these accounting litigation proceedings can they be held accountable for their actions.